Good afternoon. Welcome to Long Live Third Parties Podcast. Free Press Media Press Inc., a third parties books publisher, sponsors this podcast. I'm Andrew Bouchard. Today I read the case Freedom Socialist Party versus Bradbury, 48P3D199, Oregon Court of Appeals, 2002. Friends, today we're going to address a strict ballot access law. Friends, Freedom Socialist Party presented this case. So let's first start by giving them props. Way to go, Freedom Socialist Party. Have any of you out there voted for the Freedom Socialist Party? Maybe someday in the future they'll be on my ballot and I can vote for them. We will see. So what's the issue here? What happened? What's the bone of contention? Let's find out. It says, quote, Defendant Secretary of State, Oregon, appeals from a judgment entered in favor of plaintiffs in this declaratory judgment action, declaring ORS 248.010 to be unconstitutional. End quote. So that's good. That's a good start. In the original trial, this Oregon law got overturned. But what is the Oregon law in question? Of course, it pertains to ballot access. But what did it pertain to? Let's continue. It says, quote, Plaintiffs include the Freedom Socialist Party, an Oregon registered voter who would vote for the Freedom Socialist Party candidates in Oregon elections if possible, and an Oregon resident who would run for public office as a Freedom Socialist Party candidate were she permitted by law to do so. At issue in this case is the constitutionality of ORS 248.010, which provides that each major political party and minor political party and its nominated candidates and its members and officers shall have the exclusive right to use the whole party name or any part of it. End quote. This is talking about how you can't have the same name for one party to have the same name as another party, because that's going to cause problems. They cite another case that we did on this podcast called Norman versus Reed, which talked about the Harold Washington Party, and there was two Harold Washington parties, and they said it could cause confusion in that case. So here, it's different, because it's not just the whole name, but the last part there, any part of it. Let's continue. It says, quote, The Freedom Socialist Party, which has been in existence for some 30 years and has run candidates for office in several other states, wishes to establish itself as a minor political party in Oregon and to run candidates for office. It sent a letter to the defendant in a prospective petition to establish itself as a political party in House District 16 to that effect, and received a letter in response from the defendant refusing approval of the petition on the ground that the filing could not be accepted under the name Freedom Socialist Party because ORS 248.010 prohibited the use of the word socialist in the name of any new political party because another political party was using the word socialist in its name. End quote. For those of us who follow third parties, we know there's a lot of third parties that are socialist in nature, and usually they include socialist in their name. The Green Party calls themselves socialist, but they don't include that as part of their name. A lot of the other socialist parties do. So this is obviously going to be a huge issue if you can't use the word socialist just because another party did. The record also says, quote, The gravamen of plaintiff's complaint was that the statute violated numerous provisions of the Oregon Constitution as well as the First Amendment to the United States Constitution as applied to the state through the 14th Amendment to the United States Constitution. End quote. Again, our third-party friends are invoking the First and 14th Amendment, a theme I see again and again in these trials. The vast majority of them involve that argument. So let's keep that in mind. It continues, it says, quote, In support of their motion for summary judgment, plaintiffs filed an affidavit from the chair of the Socialist Party of Oregon, stating that although the parties had distinct political ideologies, the Socialist Party of Oregon had no objection to the Freedom Socialist Party candidates appearing on the same ballot as its candidates and had no concerns that voters would be confused about the differences between the two parties. Plaintiffs also presented an affidavit from a political science professor and author of several books about election politics who opined that the use of the word socialist in a party's name may be a central component of its identity, that voters who describe themselves as socialists are not likely to be confused when several parties use the term socialist as a component of their names, and that if a candidate is not designated on a ballot according to the name by which his or her party is generally known, voters who might otherwise vote for the candidate are deprived of a critical voting cue. End quote. That's a great move to have the Socialist Party make a statement on your behalf to show that this is not a concern that the Socialist parties are going to care about. That's very big of the Socialist Party to help the Freedom Socialist Party, even though they're different. Some would say they're rivals. So that's a very big move. I like to see that third-party solidarity. It's also a great move to have a political science professor give context to this situation. If we ever face a ballot access trial and the circumstances warrant it, we can perhaps also invite a political science professor. I hope they would agree to issue a statement on our behalf. The last part is also valid to suggest that the party's name helps a lot. Sometimes when people run for office, I'm not familiar with the candidates. Even people like us who follow politics, we can't know every candidate. We can't know everything about them. So the party name is definitely helpful in determining what they stand for. It helps us understand it. It doesn't tell everything about it, but it can tell a lot. If someone's a Libertarian Party member, you may not know every single position they have, and there's debates within the Libertarian Party. I've seen different caucuses and the like. Still, it gives you a general sense of what they're about. So I like this reasoning. The court says the crux of this is whether this is a First Amendment concern. So do you think the court here is going to side with the defendants are friends? The plaintiffs are friends, or the defendant, the state? Let's find out what they did. It says, quote, as discussed below, we reject each of the defendants' arguments. First, we reject defendants' attempt to characterize this case as a First Amendment free speech case to be analyzed based on whether the ballot box is a public forum. First Amendment association voting rights claims such as this one are not analyzed under a public forum / free speech rubric, but are analyzed under the framework summarized in the Timmons case. End quote. And then, a little bit later, they continue. They say, quote, they say, quote, it is, in fact, arguable that a statute that prevents some but not all socialist candidates from political office from designating themselves as socialists simply because they do not belong to the first Socialist Party to be recognized in a state contributes to rather than alleviates voter confusion, end quote. That's an argument the defendants are using here, voter confusion, and it's something I see again and again in these ballot access trials. The state is arguing we got to have these ballot access laws to avoid voter confusion. So they make a good point that this law is counterproductive. Because, as we were talking about earlier, when you say socialist on the label, you may not know the distinct identity of the party. You may not know if they're Trotskyists, if they're communist in nature. Some political parties that are technically communist call themselves socialist. Or you might not know if they're what factions of the socialists they support. But you know, in general, they're socialist oriented. If they can't include that, they call themselves the Freedom Party rather than the Freedom Socialist Party, it makes it very vague and ambiguous of what they stand for. So the socialist label definitely helps. And yes, it's ridiculous to suggest just because one party is socialist, another party can't use that part. It'd be one thing to say you can't have Socialist Party and Socialist Party, both with the same name, Socialist Party, or two Freedom Socialist parties. But here, that's ridiculous. Unfortunately, the judges see our view. They say, quote, while a state has an interest in preventing voter confusion that may justify at least some restrictions on parties' choice of names, a restriction that prohibits a new party from using any part of the name used by another political party sweeps too broadly and may in fact cause more voter confusion than it alleviates. The trial court correctly concluded that ORS 248.010 is unconstitutional, end quote, and they say ultimately, quote, affirmed, end quote. Affirmed. I like those words. I like that word when it applies to a trial court judgment in favor of our side. And that's what happened here, friends. So the Freedom Socialist Party are underdogs in the grand scheme. Here they scored a victory. So let us root for them in this and their continuing endeavors. Long live third parties. Goodbye.